was made for hearing by the Commission on 14 January 2020, but it could not be heard on that day because former President Zuma filed a 105-page affidavit on the day before instead of 6 January 2020. Seventh, because of that lengthy affidavit filed on the 11th hour, the substantive application for the issuing of a summons could not be heard on 14 January. And on 27 to 31 January, which are dates the summons was to have required former President Zuma's attendance, the hearing could not take place. Eighth, and more importantly, it went all quiet from then, that is from January of 2020 until 10 August 2020, when the Commission chairperson determined 21 to 25 September as fresh dates for former President Zuma's appearance. Ninth, and I'll cut out a bit of detail here, there was another failed set down, and then the recusal application came soon thereafter. And that takes us to where we are. Here are my difficulties. Starting with former President Zuma's quote-unquote withdrawal from the Commission proceedings of July 2019, attempts at holding a hearing were never successful. I have difficulty with the notion of a substantive application on affidavit before the Commission chairperson could authorize the issuing of a summons. Why must a summons be issued only after an adversarial process? And as you are aware, there were a good few attempts at holding this substantive application, all of them to no avail. Maybe there's something in the rules or somewhere, I do not know, but I just do not understand why there should be a substantive application in a way that appears to have been adversarial. There are affidavits by the commission, there were to have been affidavits by former President Zuma, and a date was set down for argument, a full adversarial process. I do not understand at all. And as I say, and I underline, this was attempted more than once. In my book, unless you are able to explain to me that this substantive application was necessitated by ABC, to me it seems that it was all a total waste of time, or was it not? Then there was the deafening silence, as I say, from 14 January 2020 to 10 August 2020. All the while, the Commission was aware of the fast approaching terminal point of the Commission's life. Crucially, the Commission's affidavit does not explain that, or this near 7-month silence. The affidavit filed by the Secretary of the Commission is totally silent as to why former President Zuma could not have been called between January and September of this year. All of a sudden, the Commission cries urgency, and this court now has to sit and hear this application on 29 December 2020. Is this not a classic case of self-created urgency?
Thank you, Justice Madlanga. The answer is no. To deal with, firstly, the issue of the withdrawal, the court will remember that subsequent to that withdrawal, an agreement was reached between Mr. Zuma and the Commission, in terms of which Mr. Zuma agreed that he would file an affidavit, a substantive affidavit. He nevertheless failed to submit that substantive affidavit, dealing with what was referred to at that stage as areas of interest. Instead, when the Commission issued further dates, the attorneys acting for Mr. Zuma protested at the issuing of those further dates, and they claimed that those dates could not be issued unilaterally. But they reneged on an agreement that was reached in good faith by the chairperson of the Commission. Secondly, insofar as the period January to August The explanation given in the founding affidavit is that the longer period, which was 3 months of that 7 months, is accounted for by the lockdown, which is no one could come to the commission at all. Not Mr. Zuma, no other witness, because for a period of 3 months, there was simply, the commission did not sit. The commission began sitting subsequently in June, July. When it began sitting subsequently, it did two things. In August, it issued a 27th of August, it issued a Regulation 10.6 notice to Mr. Zuma. Now, the court will recall that that Regulation 10.6 notice to Mr. Zuma comes in the back of more than 30 Rule 33 notices. Every time Mr. Zuma is implicated or may potentially be implicated, a notice is issued to him. He has ignored all of the 36 Rule 33 notices. In September, on the 7th of September, another Regulation 10.6 notice compelling Mr. Zuma to issue an affidavit in response to evidence that implicated him is issued. There is again no response. So it is not a fair characterization of the evidence that there is a deafening silence. As soon as the commission returned to work, first item was the Regulation 10.6 notice in August. Second item was the Regulation 10.6 notice in September. Those are ignored. Subsequent to that, a decision is then taken that he must be compelled by virtue of a summons. What we know about that summons is that his attorneys played hide and seek about whether or not he will even appear. And eventually, their hand was revealed when they did what? When they decided that they would apply for the recusal of the chairperson. But that application for the recusal comes very late in the process. So if one actually looks at the totality of the pictures, Justice Matlanga, the commission has employed 5 strategies to get Mr. Zuma to account. First, it was an open invitation in 2018, which Mr. Zuma eventually came in July of 2019. But on the 15th of July 2019, he withdrew unilaterally. A decision was taken that he should be forced to come to the commission. But then an agreement is reached with him. So second strategy is to reach an agreement with him. But he agrees with the commission that he will submit a substantive affidavit on areas of interest. Mr. Pretorius then gives him a list of areas of interest per witness. Mr. Zuma refuses to answer those areas of interest. Now, this is against the background where his own attorneys have told the commission that the affidavit in response to the areas of interest is ready. They told the commission that the affidavit was ready, but they never filed it. Once the areas of interest are issued, an affidavit is promised and not delivered. Again, the commission, in good faith, is nevertheless willing to entertain him further. The third is the Rule 33 notices. Mr. Zuma is in receipt of 36 Rule 33 notices. The fourth is the period is interrupted by the lockdown. As soon as the lockdown is lifted, Mr. Zuma receives a Regulation 10.6 notice on the 26th of August. Mr. Zuma receives another Regulation 10.6 notice on the 7th of September. He subsequently, and this inclusive of the regulations issued under 10.6 of the directives of the Commission. The last one is costs. If I could deal with the first issue of jurisdiction and urgency. This application is brought as an urgent application under Rule. This application is brought as an urgent application under Rule 12, illustrating that this is a self-created urgency. The facts show that the Deputy Chief Justice has bent over backwards to try and accommodate Mr. Zuma. There was even a point in 2019 when Mr. Zuma said, I cannot come because I'm sick. I cannot come because I have to see a doctor. In those circumstances, the chairperson has been more than accommodating in relation to Mr. Zuma. Mr. Zuma's response, on the other hand, has been of belligerence, of defiance, and ultimately of contempt. So the facts do not show, in our respectful opinion, submission, the facts do not show self-created agency. What the facts show is the Deputy Chief Justice trying to accommodate a former president. And ultimately, the Deputy Chief Justice has no choice at this stage. It's simply too late. So those are the explanations given in the papers, and we would submit with respect, those explanations simply illustrate a painstaking effort by the Deputy Chief Justice to accommodate a witness. But he has now run out of options. Mr. Zuma has run out of options because he can no longer use the previous excuses that he has been given. On the other hand, one can see what the goal is. The goal is to run out the time until the commission's tenure finishes. If he runs out the time successfully, in March next year, the commission's life would be over. Mr. Zuma would have avoided accounting for his alleged criminal behavior while in office. So those are the submissions with respect.
Thank you. Fair enough, Mr. Ngoitobi. Can you please explain to me the full-blown adversarial process for the issuing of a summons? As I indicated in the summary I gave, the need for the issuing of a summons was seen in December of 2019. If a summons had simply been issued in December of 2019, say, for example, for a date in January of 2020, instead of in January 2020, setting down the substantive application for the issuing of a summons. So instead of that, rather issuing a summons for an appearance in January of 2020. So can you please explain the need for a substantive application?
Yes.
Totally confused as to why that was necessary. And as I say again, that was a total waste of time. And if my recollection is correct, I think there were a couple of other attempts at those substantive applications later on.
Yes. I mean, what had happened with that substantive application, the court will find from the explanations given from pages 53, and then it goes on right up to 62. It was a progressive attempt at getting Mr. Zuma to come to the hearing. First, as I explained, it is an invitation, a soft form, a public invitation, effectively a plea by the chairperson. The second one, it is then a letter inviting him. The third one, it is then a notice under Rule 3.3. Mr. Zuma has always taken the view that he will cooperate and that he will provide his version to the...
I've seen, I'm very sorry to interrupt you, Mr. Ngoitobi. I've seen that background and I've seen build up. What I want to establish is once a point was reached that it is now necessary to issue a summons, and this is as far back as December 2019. So once that point is reached, why not simply issue a summons in December 2019 for an appearance in early 2020? And that appearance could, for example, have been in January 2020, the dates, or rather the date on which, instead of an appearance for the giving of evidence, what was done was rather to set down a substantive application.
Yes.
On board.
Yes. No,
So what I'm saying is, why not simply issue a summons in December of 2019, I'm sorry, for an appearance in early 2020?
Yes. But
a full
yes.
Adversarial process.
So, Justice Madanga, I take the point. One must remember that Mr. Zuma perceived the issue of the summons a hostile act on its own, because he claimed that he would cooperate with the commission. He was taken on that claim in good faith, and hence he was given an opportunity to come and explain why a summons ought not to be issued against him, against the background of his own claims that the commission is acting in a hostile manner towards him. And it is in that context that a decision was taken that there should be effectively an opposed application about whether or not a summons should be issued against him. But if one looks at the totality of the picture, what Justice Zondo is trying to do is try to invite Mr. Zuma to come to the commission without any hostility. When he has to resort to the issuing of a summons, which is a serious step in the process of securing his attendance, Mr. Zuma's attitude through his attorneys is to regard that step as hostile towards him. He is then offered an opportunity to come and oppose the issuing of the summons, which they subsequently do by filing a substantive 103-page affidavit, virtually
105.
Not 103 years. I lost it by 2 pages, 105 pages affidavit at the last minute. So the explanation, Justice Madanga, is that it's because Mr. Zuma perceived the issuing of the summons as a hostile act towards him, and he used that to perpetuate this myth that there is somehow an agenda against him. And Justice Zondo is simply being fair to Mr. Zuma by asking him to come and oppose and give an explanation why a summons ought not to be resorted to. With the benefit of hindsight, one might say that the aggressive step should have been taken much earlier, but that's much better for us reviewing the steps. But at the heat of the moment, at the time the events were unfolding, one can perfectly understand why a chairperson of the commission, primarily who depends on the cooperation of the parties and not by employing steps of cohesion, one can perfectly understand why, if you're running a commission and your primary method of inviting witnesses is their own voluntary appearance, one can understand why, if you are going to resort to non-voluntary, compulsive methods such as issuing of a summons, one can understand in those circumstances why you would say, if you're saying I'm targeting you unfairly, well, come and explain why the summons ought not to be issued, which firstly he didn't do, and then he finally did. And one of the points you will recall, Justice Madlanga, which they have been hoisting up all the time, one of the points is that you don't even believe us when we say we are sick. And if he had been hospitalized, think of the example, if he had been hospitalized, and nevertheless a summons was issued despite the fact that he was bedridden, imagine the criticism that would have befallen Justice Zondo, that again he is targeting President Zuma, again he has an agenda against President Zuma, because he does not even believe the explanation given that the man is bedridden. So in those circumstances of simply affording fairness to President Zuma and affording him an opportunity to dispute why he believes that the so-called act of hostility should not be resorted to at the time. So that is the explanation on the papers.
Thank you, Mr.
Thank you, Justice.
Mr. Enright, I have difficulty with it.
Yes, Justice.
First, as at November 2019, Mr. Zuma had already displayed non-cooperation with the Commission, and that led to the Commission considering issuing a summons. Now, I don't understand why, for fear of criticism, the Commission would not employ its coercive powers to a witness who has already displayed that he is not cooperating with the commission. That's the first point. The second point, I don't understand why a procedure that is not sanctioned by the provision that empowers the commission to issue a summons is followed in circumstances where already the witness had shown no intention to cooperate.
Justice Jafta, if one looks at the, I would say, the conduct of Mr. Zuma, at what point does one say that it had become crystal clear that he will not cooperate? Because throughout the evolution of the interaction between him and the commission, he had always disputed that he is not cooperating. And he had always insisted that he is in fact cooperating.
No, but you have just catalogued events which displayed before November 2019 that he was not cooperating. The 36, is it regulation?
It is rule
notices.
3.3.
Yeah.
Yes.
He had not cooperated in respect of those. And correct me if I'm not, if I'm wrong in saying he had also not cooperated in respect of some, is it regulation 10.6?
Regulation 10.6 of August and September 2020.
Exactly. So you had that kind of a witness. And the commission, by law, is given coercive powers. It doesn't employ its coercive powers when it had already contemplated issuing someone, seeing that the witness is not cooperating. It raises the issue of issuing summons outside the requirements of the empowering provision. It requires the witness to oppose the application for issuing summons if he so wishes. I don't understand that. If it is not self-created circumstances, what is?
Justice Jafta, if we look at page 58 and 59 of the papers, that's where the facts are answered in relation. As I understand, your question has got two legs. The first one is, what about the first summons that were contemplated? And the second one is, what about the second summons? So if we start at page 58, paragraph 102, it says, on 6 January 2020, Mr. Zuma's attorneys advised the commission that their offices had been closed and that they had only received the application on returning to the office that day. And now this was the application for the summons. They gave notice of Mr. Zuma's intention to oppose the application for a summons and undertook to file his answering affidavit before the close of business on 10 January 2020. However, on 10 January 2020, Mr. Zuma's attorneys advised the commission that his answer affidavit in the application for the summons could not yet be filed, as Mr. Zuma had undergone a medical surgery procedure on 6 and 9 January 2020. And we attached the letters at IM 32 and IM 33. On 13 January 2020, on the eve of the scheduled hearing for the application on 14 January, Mr. Zuma filed a bulky answering affidavit of 105 pages, excluding the annexures. One of the grounds advanced by Mr. Zuma in his opposing application for a summons was that he was then scheduled to receive medical treatment abroad, which would result in his unavailability to appear before the commission until the end of March 2020. Now, it is clear from here what the position of the chairperson of the commission was, which was this: you claim to be sick. I want to give you an opportunity to put your side of the story before I issue the summons. It is not a mere fear of criticism But one can imagine, Justice Drafter, with respect, the chairperson of the commission issuing a summons in the face of a letter that has been received from Mr. Zuma's attorneys, that Mr. Zuma is receiving has undergone a medical procedure and is currently receiving medical treatment until March 2020. In those circumstances, it would have been a prudent and a responsible thing to do to afford him an opportunity to put an answering affidavit before the commission so that he can deal with the issue of his medical treatment.
Do you agree that that was not required by law, that process which the commission followed?
No, Justice Drafter, I don't accept that it was not allowed by law, because
required, not allowed, I'm saying required.
Yes, well, Justice Drafter, I don't accept that, because there was an application by the evidence leaders to the chairperson. That application was served on Mr. Zuma. Mr. Zuma then exercised his rights as he was entitled to oppose it.
No, you're missing the point. The point is, do you agree that the need for an application for the issue of summons, which was to be served on the witness required to be summoned, it's not required by law? Or if it is, please draw my attention to the provision of the law that says a commission of inquiry applying the Commissions Act before issuing a summons must initiate an application that could be opposed by the witness.
Well, Justice Drafter, I mean, there are two answers to the question. The first one is that a commission of inquiry, as everyone knows, is a special animal. It is created under the Act. One of the special powers residing on the chairperson of the Commission of Inquiry is to ensure that he acts fairly. And that includes, within its parameters, that includes fairness in relation to the exercise of coercive powers. If, as you can see at paragraph 101, 102, and 103, if the evidence leaders intend coercing a witness to appear and to give evidence, the witness on their own says, do not make the application because I am bedridden. It is the correct thing for the chairperson of the commission to do, to set down an opposed application, so that...
Look, Mr. Ngolato, I'm sorry to interrupt you. I think the issue is in two parts.
Yes.
I don't see any unfairness, and please show it to me if I'm wrong, in the process of issuing summons. There may be unfairness in requiring the witness that is summoned to come before the commission, to come on a date which is not suitable to the witness. For example, if the witness is bedridden, then that I can understand. The issuing of summons, the process of issuing the summons itself, it seems to me to be a separate process. Whether the dates are good or not, it's an issue that can be debated later. And if the witness puts before the commission compelling facts that the dates would not suit the witness, I am sure the commission would look at alternative dates. What I don't understand is, to start with, to say the very issuing of the summons itself must be a process that involves opposition from the witness.
No, Justice Drafter, I think we are both on the same page as far as that issue is concerned. What I'm submitting to the court is, if you have a witness who says, do not resort to the coercive powers, I want to make submissions as to whether you should or you should not. It is not, the chairperson of the commission is not acting unfairly when he says, let me know what you would like to say before I employ my coercive powers. Because this is a sui generis animal. It is only required to act fairly. You have, as you can see on the facts, you have the evidence leader saying, we've been trying to get you to come to the commission. You have not come through voluntary means and through non-coercive means. We are now about to resort to non-coercive means, which is the issuing of a summons. At that point, the witness says, please hear me out. The question for the chairperson is whether or not to allow that witness to make representations before they issue the summons or not. As a matter of fairness, it may be that they are being too generous, but as a matter of fairness, the chairperson cannot be criticized for allowing the witness to make representations, because on the facts, it was the witness, through his attorneys, who said, I want to oppose the application, I have submissions to make. And one must remember, that's on the second point, one must remember the summons already contained contemplated dates for the hearing and the presentation of the evidence of Mr. Zuma. And it was on that basis that the attorneys then also said, Mr. Zuma effectively is out of commission between January and March 2020. So the submission we make is this: if a witness says in the middle of the contemplation of the employment of coercive measures, I want to say something about the employment of those coercive measures, it would probably be a criticism against the chairperson if he simply closed his mind and said, I'm not interested at all. I don't even want to hear anything that you have to say. I'm going to issue the summons. The only point I want to debate with you is whether or not you should do so on a particular date. Given the fact that Mr. Zuma always pleaded his cooperation, and given the fact that there was an objection, it was fair for the chairperson to hear him out, not necessarily to agree with him, but to hear what he has to say. In the event, on the facts, Mr. Zuma said he was unable to come as a consequence of a medical procedure he was undergoing, and that medical procedure would take him up until March 2020. We know in March 2020, there was subsequently a lockdown. We know when they returned from the lockdown, they issued the Regulation 10.6 notice, which did not require his personal appearance, but only required an affidavit. We know another affidavit, another 10.6 notice is issued in September, which again does not require his appearance, but merely requires an affidavit. None of those are complied with.
But
Mr. Mugaitobi. Mr. Mugaitobi.
Sorry, I don't see. Oh, yes, it's Justice Matopo.
Following upon what my brother Madlanga and Jafta put to you, is it a fair characterization of this matter to say that one has to balance sympathy/fairness with the procedural rules? You have made submissions that Justice Zondo had to accommodate former President Zuma on numerous occasions to ensure his attendance at the commission, despite him failing to comply with directives which my brothers have taken you through. If I understand your argument correctly, you take the point that as at that time, it would have been imprudent of the Deputy Justice, Chief Justice rather, to issue a summons at that stage instead of opting to accommodate the President. Now comes my question. Given all these backgrounds and the troubles, if one looks at the summons that has now been issued, which necessitated today's hearings, would one be correct to say that the urgency of this matter is precipitated by the fact that the deadline for the hearing, for the Commission's hearing, is looming, and would one be fair to suggest that if the deadline was not as imminent as it is now, perhaps we would not be sitting here today?
Justice Matopo, just to clarify the issue of the directives, just to make sure that we are on the same page on the facts. The directives under Regulation 10.6, those are mentioned at page 60, at paragraph 107. It's not in 2019, it is on the 27th of August 2020. It is then delivered on the 28th of August 2020. The next directive is mentioned at page 61, at paragraph 111. It is again not in 2019, it is on the 8th of September 2020. So those are the directives. What had happened before that process were three things. Firstly, it was a letter of invitation issued in 2018. Mr. Zuma came to the Commission in July 2019. On the 15th of July 2019, he withdrew from the proceedings on the basis that he was being subjected to unfair questioning by Mr. Pretorius. Subsequent to that withdrawal, an agreement was reached by Mr. Zuma. He breached that agreement. Subsequent to that, several regulation Rule 33 notices. Now, there is a distinction between a notice issued under Rule 3.3 and a Regulation 10.6. And a notice issued under Rule 3.3 is optional. It simply tells you that there is a case made against you. You may or may not wish to respond to. But the point that is made is 36 of those have been ignored. But a Regulation 10.6 is not optional. It is compulsory. Those regulations are issued on the 27th of August and on the 8th of September 2020. So it's crucial to just draw that distinction. Now, to come to the question as to whether or not, if it had not been for the looming deadline, we would not be here. I would say with respect, we would probably still be here, regardless of whether there was a looming deadline or not. The reason I say this is because Mr. Zuma has indicated in correspondence through the utterances of his counsel on the 19th of November and subsequent correspondence that he will not appear at the Zondo Commission. And that is not linked to the time of the 31st of March. It is linked to the defiance of Mr. Zuma. So whether or not the commission finishes on the 31st of March or finishes on the 31st of December 2021, Mr. Zuma has expressly indicated that he will not appear. He has made it clear before Justice Zondo that if he is forced to appear, he will sit and say nothing. He has also indicated in correspondence issued by his alter ego, the Jacob Zuma Foundation, on the 19th of November, that he will not subject himself to the Justice Zondo Commission because it is a manipulated and a biased process. So the two must be kept separate. Mr. Zuma's contempt for the legal process would have driven us to be at the Constitutional Court at any rate. But the timing is also important because any commission of inquiry must have a specific beginning and end point. So it would have still been necessary to come to the Constitutional Court to compel Mr. Zuma to appear and to account, irrespective of whether the deadline is the 31st of March or a later deadline, because the critical point is a witness who has shown contempt for the Constitution.
So, Mr. Nukaitobi, if I were to follow that up, perhaps in your favor.
Yes.
If one were to contextualize this case, and given the indulgences that were afforded to former President Zuma by the chairperson of the commission, and to a point where there were a variety of reasons advanced for non-compliance with the directives of the Commission. If one zoom in on the 27th of August as well as the 8th of September,
Yes.
and what happened in November 2020,
Yes.
would one then say the urgency of this matter, Zuma, former President Zuma expressly said he is not going to be participating, and if he's forced to participate, he will attend and keep quiet. So that would zoom in, if I were to put it that way, the urgency why this matter has to be heard now. Would that be correct?
That is correct, Justice Matopo. I think if there was ever any confusion about whether Mr. Zuma is a recalcitrant witness or not, it was put to bed on the 19th of November, because the recusal application at that point is dismissed. Mr. Zuma is then required to take the witness stand. Mr. Pretorius tells the tribunal, the commission, that he has no right to leave. Mr. Zuma's counsel tells the chairperson that we are excusing ourselves. He never asks for permission. He asserts his entitlement to excuse himself. He claims that there is a review application that they will institute, but never suggests that pending the resolution of that application, they are not obliged to appear. At that point, the urgency is now crystal clear. There is no more confusion about Mr. Zuma's actual attitude to the commission. That is then reinforced by Mr. Zuma's alter ego, the Jacob Zuma Foundation, at page 138 and 139, where they make it clear that we've left the commission, we're not going back. At that point, the case truly becomes extremely urgent, because it becomes clear that Mr. Zuma is not coming back. He has defied the summons, and he has defied the instructions of the Deputy Chief Justice.
Mr. Nkotobi, can I ask you this on the question of self-created urgency? It seems to me that the Commission is a sui generis entity, as you've said.
Yes.
And that we should be cautious about applying what would be the High Court rules pertaining to urgency.
Yes.
The purpose of the Commission is to elicit the truth. And as I understand it, a fair and reasonable and non-aggressive approach was specifically adopted.
Yes.
Then juxtaposed to that was a carefully orchestrated stratagem to run out the life of the Commission. This is not like the High Court, where the role is ongoing ad infinitum. The Commission, as you said, has got a life, a beginning and an end. So my question to you is that it seems to me that the rules of urgency should be adjusted to the specific entity that one's dealing with. And it seems to me that for this matter, for exceptional circumstances not to be found, would really result in what the Helen Suzman Foundation said, is that the South African citizen has got a right to the truth. It is a customary international law that there is a right to the truth. And this Commission is trying to establish that truth. So my question to you is it then clear that the rules pertaining to urgency are not in the High Court are not the same as when you're dealing with the sui generis entity? As my brother Matopo said to you, it seems to me that there should be a different and a more nuanced approach to urgency.
Indeed. What I would add to that, Justice Victor, is that in exercising your own discretion as to whether to deal with the matter on an urgent basis, you will be informed by the principal standard of the interest of justice, which is a broader standard. And when you examine what is in the interest of justice, you will take into account the special nature of the commission. You will also take into account that this is a commission that did not emanate from the president as commissions of inquiry usually do. It came from the outcomes of the remedial action by the public protector. You will also take into account that this commission was endorsed by the full bench of the High Court. You will also take into account that the mandate of the commission is to investigate serious crimes that are said to have taken place under the presidency of Mr. Zuma and engineered by Mr. Zuma himself. You will also take into account that Mr. Zuma not only is one of the principal accused before the commission, but Mr. Zuma set up the commission. And you will also take into account, fifthly, that Mr. Zuma is being called to account as former president. And you will also take into account the variety of testimonies that have implicated Mr. Zuma. Mr. Zuma is implicated directly, not indirectly, directly by members of his own cabinet. It is members of his own cabinet, Minister Nhlanhla, who say to the commission that Mr. Zuma put me under pressure to sign the nuclear deal with the Russian government, despite the fact that there was no money for it, and despite the fact that there was no compliance with the PFMA. It is people like Minister Pravin Gordhan who implicate Mr. Zuma directly. It is heads of independent institutions, the Hawks, the NPA. The list is endless, Justice Victor. So if one is to take a step back and say, what standard do I apply in deciding whether I should hear the case or not? The overarching standard is interest of justice, and the Constitutional Court must ask itself whether or not it is in the interest of justice to nitpick about an allegation that should have been in the founding affidavit but is not, or a case that is not sufficiently made out in the founding affidavit on urgency, or the fact that Justice Zondo deliberately bent over backwards to accommodate a witness who has subsequently revealed his hand as being contemptuous, belligerent, and quite frankly not interested in telling the truth. So if one is to apply the broader interest of justice standard, it seems to us that if you balance what Justice Zondo did versus the reaction that he has received from Mr. Zuma, a reaction essentially of contempt. Not only has Justice Zondo been treated with contempt by Mr. Zuma, the Constitutional Court has not been spared from the contempt. Mr. Zuma did not simply file a notice to abide. He wrote a letter when he received these papers. That letter reinforced Mr. Zuma's contempt for the law. It told the Constitutional Court that he is not participating at all in these proceedings, which again means, Justice Victor, that even before the Constitutional Court, Mr. Zuma is still not interested in providing explanations. He should have told the Constitutional Court, why did he walk out before the Deputy Chief Justice? Did he do so under legal advice? Did he give an instruction to his counsel? Why did he promise to deliver affidavits and then not deliver them? What does he say in relation to the 36 witnesses that have directly implicated him? But he has deprived even the Constitutional Court of the benefit of his version. So in those circumstances...
Mr. Lukachobi, can I ask you this then? It seems to me that your argument is clear, that,
yes,
that there is a right to the truth. And if urgent access, direct access is not granted, the life of the commission will come to an end and the truth will not be known.
Yes. What is necessary in that regard, Justice Victor, in fact, we got to deal with urgency for the past hour. Perhaps this is the right time to move on to the next two topics of my address. The first one being the question of direct access versus exclusive jurisdiction. The court will remember that we have come to the court based on exclusive jurisdiction and on direct access. This court will remember its own jurisprudence from the judgments in UDM versus the Speaker of Parliament and the case of Zulu versus Sisulu. In those cases, what the court was confronted with is an exclusive jurisdiction application, alternatively direct access application. But what it did in relation to both of those cases was to first examine direct access and thereafter to consider whether exclusive jurisdiction should be decided at all in the light of the fact that direct access was granted. We would commend that approach as a salutary approach. That what is really at issue here is whether we should be entitled to direct access. Yes, Justice Mhlanhla.
Mr. Mukaitobi, why do you say this court? Why do you say this court has exclusive jurisdiction to entertain this matter?
Yes, Justice Mhlanhla, what I am suggesting, certainly in oral argument, is that the way in which the analysis should commence is by deciding whether or not there is direct access. And if there is direct access, the exclusive jurisdiction point need not be entertained at all.
And if that is the case, what are the other exceptional circumstances that would warrant the granting of direct access?
Yes, so the real question then is, as you point out,
you've touched on urgency.
Sorry, Justice.
You've already touched on the question of urgency. What are the other exceptional circumstances?
Thank you, Justice Mhlanhla. So let me deal then with firstly, we've dealt with the question of why the case is urgent. The second reason for direct access are the nature of the constitutional obligations that flow from Mr. Zuma's holding of office as president. We have dealt with Section 1D, which is the principle of accountability. We submit that that principle of accountability does not terminate simply because Mr. Zuma is no longer the president. Mr. Zuma remains accountable for the way in which he exercised public power as the president. Secondly, we have referred to the obligations imposed on Mr. Zuma to uphold the Constitution under Section 83 of the Constitution. This is a matter dealt with extensively in the context of exclusive jurisdiction in the Ngandla case, but we would submit it applies with equal force on the question of exceptionality for purposes of direct access. Then Section 182(1)(c), I pointed out earlier in response to the question by Justice Victor that this is a special commission because its genesis does not lie in a presidential act alone, but it lies in a decision made by the public protector, subsequently endorsed by the High Court, in circumstances where Mr. Zuma, in fact, attempted to stop the commission from being established through a review application which was dismissed. Another cluster of considerations beyond accountability are the rule of law considerations. Mr. Zuma has defied the commission. I'm sorry, Justice, there is someone ringing a bell outside and I'm sitting here by myself. So if I might get a second to just stop them.
You may do so, Mr. Mukaitobi.
Thank you.
Mr. Mungayitobi, are you back?
Yes, I'm back, Justice Khampepe. Thank you very much, and many apologies for
I hope you have a big "Do Not Disturb" sign outside now, Mr. Mungayitobi.
Justice Madlanga, this is not my house, so I don't think I'm entitled to put signs. Thank you. So if I may proceed then, the second category are the rule of law concerns. I've debated the issue of the facts in this case. What they show is a well-orchestrated and a deliberate defiance of the commission by Mr. Zuma. If this is allowed, it brings the rule of law into disrepute, and that is a breach of Section 1C of the Constitution. But another feature of the rule of law concerns is that Mr. Zuma, through his alter ego, the Jacob Zuma Foundation, is actively attacking the commission. He is also actively attacking the judge, Mr. Justice Zondo. This much is clear at page 138 and 140 of the papers. I don't want to take the court through those statements, but the vicious language that is employed by Mr. Zuma and his supporters, the Jacob Zuma Foundation, against not just Justice Zondo, but other persons associated with the commission would make one cringe. And so the third category is what has been pointed out by Justice Victor, which is the principle of transparency and openness, which is also a founding principle of the Constitution. And here we fully associate with the Helen Suzman Foundation and the submissions made by Mr. Du Plessis, where he says that the way in which the transparency and openness considerations apply is that Mr. Zuma's deliberate act of defiance denies the public the right to know the truth. The public is entitled to know what happened. The public should know what happened to Mr. Zuma's presidency. Did he subvert the office of the president to serve his family and his friends, the Guptas? One must remember that it is Mr. Zuma himself who described the Guptas as his friends. The public is also entitled to know the extent of the corruption and fraud which is alleged to have been engineered by Mr. Zuma. And here, the public must know whether or not the funds that should have been used for the fulfillment of the socio-economic entitlements in the Constitution were instead diverted towards corrupt ends. So these are important constitutional questions. The case is also exceptional. This is not a run-on-the-mill case. This is not any other commission, but from the remedial action and flowing from a judgment of the High Court. This is not any other witness, but this is a witness who once held the highest office in the country. The issues and the scope of the mandate of the commission are considerable in their breadth. If one looks at the terms of reference, these are extraordinary questions of alleged criminal behavior by a head of state. Is the defiance of a legal institution by constitutional issues. We have exceptional circumstances that simply illustrate that
the 2nd of January 2021, as well as the 15th to the 19th of February 2021.
Had you approached the High Court the same relief that you are seeking before us could have been granted. And if I'm wrong on that, you would tell me why this relief that you're seeking, the High Court could not.
Yes.
What we now know is in these proceedings, we have, instead of receiving a notice to oppose or stuff like that, we have a letter from the attorneys saying we don't want to proceed to participate in the proceedings at all. If one were to have a crystal ball and look into what could have happened, maybe the High Court could have granted the order. Maybe the same stance that is adopted by the former president could have been adopted in respect of the proceedings before the High Court, and this court would not have been burdened with this application. I take your point about the issues relating to accountability obligations and the rule of law. I just want to be explained further why bypass the High Court and not here.
Yes.
And come to this court directly.
Yeah, Justice Matobo, just to, on the structure of the argument where we are, I'll answer the question in a second. I've explained to the court the question of urgency, and I've explained to the court the nature of the constitutional issues that are implicated and why those are exceptional. One point remains on the exceptionality before I deal with the absence of alternatives, which is that the was based on a judge selected by the Chief Justice. So it is an extraordinary set of events. If we are right in characterizing Mr. Zuma's conduct as an engineered and a deliberate strategy to frustrate the commission, we know that there would have probably been an appeal. We know that an appeal to the Supreme Court of Appeal would have taken probably a year to finalize. We know any appeal from the Supreme Court of Appeal to the Constitutional Court would also have taken another year to finalize. So the enforcement through the High Court process would have outlived the life of the commission by many months.
No, but don't you think, excuse me, but don't you think you could have asked for expedited hearings before the High Court as well as the SCA? I know the SCA would have granted you that expedited hearing.
Even if you
and I mean, taking into account the fact that the deadline was looming, I think the president of the JP in the High Court as well as the president of the SCA would have accommodated the commission application by giving or affording you expedited hearings, as we have done it today.
Yeah. Even Justice Matopo, even if you factored in the possibility of expedited hearings, those usually work when you are dealing with a cooperative respondent, not a recalcitrant respondent whose intention is to run out the time. So the first problem you have is that you've got a respondent who is acting in a calculated fashion to run out the time so that he doesn't have to answer. So the assessment of one's choice, whether to exercise this court's concurrent jurisdiction with the High Court, must take into account the respondent and the realistic respondent, not any respondent. In other words, Mr. Zuma and his conduct so far. So the first problem you have is Mr. Zuma is not interested in cooperating with the commission. He is also not interested in answering to the application itself. In those circumstances where he left the commission on the basis that he would be bringing a review application, he subsequently brought it. His attitude is clearly that he is not coming to the commission, and his interest is that there must be a determination and an adjudication of his recusal application. So it would still be an unrealistic possibility to assume that the High Court and the Supreme Court of Appeal and the Constitutional Court would all hear this case combined before the Commission's tenure is finalized. It would still be totally unrealistic.
Mr. Nkatobi, I think we've dealt at length with the question of direct access, and speaking for myself and as things stand, I'm not really concerned about that. I'd like to hear you about some of the substantive matters. I'll later get to remedy, but first now, the question of ongoing accountability. One accepts that it's not spelled out in the Constitution that a former president is on an ongoing basis to be held accountable for what he or she has done while in office on the two legs which you expound in the heads. But what I'd like to check with you is, if it is not spelled out in the Constitution, I suppose one has to then interpret the Constitution, the ethos of the Constitution, what is its purpose when you deal with accountability that's ongoing in respect of a former president, not so?
Yes, indeed. I think what we submit, Justice Majid, is that if you look at the nature of the duty of accountability, it is often a backward-looking duty, because you are always required to account ex post the making of decisions. The question is whether or not the resignation as president interrupts that obligation to account on an ex post basis. So once one looks at the nature of the duty of accountability, that it is usually backward looking by definition, it seems then the distance from that conclusion to the conclusion that it is ongoing is not far. Secondly, if you look at the nature of the allegation, so there is the nature of the duty, which we say is always backward looking, because you always have to account ex post in relation to decisions that you made or your conduct. You look here specifically in relation to the nature of the allegations. You have two primary instruments. The first is the remedial action of the public protector. The second is the terms of reference. Those terms of reference and the remedial action specifically refer to the president. They specifically refer to Mr. Zuma. You then look at the nature of the allegations that are set out here. What you get, we've explained on the papers, the allegations from pages 15 to 30 of our heads of argument. There are 30 names that are mentioned in the summons. People who have spoken directly in relation to Mr. Zuma. You look at the nature of the allegations that they have made. We don't have to go through all of them. We can take probably 3 or 4. The case by Mr. Nhlanhla Nene, who says, I was personally put under pressure by Mr. Zuma to sign the letter of agreement with the Russians. There was no funding for it. No proper PFMA procedures were followed. You take the allegation by Mr.
November 2020. As well as to the 19th of
The second cycle on the accountability line is not only the nature of the function, but it is also the nature of the case that Mr. Zuma is required to answer. It is personal, it is specific, and it implicates him in a direct way. These are not witnesses who say, I heard from someone else. These are witnesses who say, Mr. Zuma told me that I should sign the nuclear deal. So that's the second primary consideration that we would say the court should take into account in imposing the duty of accountability on Mr. Zuma. The third element, I have touched upon it, which was in response to Justice Victor. The accountability obligation is reinforced by the entitlement of the public to know the truth. A commission of inquiry, this court has held in at least two judgments, Sarfu and the Western Cape case, by definition is set up to investigate traumatic events that have destabilized a nation. Nothing could be more traumatic in the past 10 years of the President Zuma administration than the allegation that the state was captured in order to service private interests which have nothing to do with the primary function of the state under the Constitution. The public is justifiably entitled to know.
Mr. Ngulaitobi, I'm sorry.
Yes, Justice Jafta, sorry.
If we get past, and I'll get back to it, the issue of direct access, which bothers me, troubles me a lot. If we get past that and we get to the merits of the matter, is it necessary for this court to determine whether Mr. Zuma has to appear before the commission on the basis of an obligation to account? Or all that we need to do is to say, the commission has issued summons, it has issued directives, which are legally binding. You have to comply with those. Zuma has to appear before the commission on the basis of an obligation to account. Or all that we need to do is to say, the commission has issued summons, it has issued directives, which are legally binding. You have to comply with those summons and the directives and appear before the commission. Do we need to add another leg that your obligation to appear rests on the obligation to account? As it seems to me, once Mr. Zuma is obliged in terms of the summons and the directives to do what the commission requires, he will be before the commission, and as a witness, he will be treated as a witness in accordance to what Section 3 of the Commissions Act says. If he is entitled to protections, as I understand your argument, he'll be entitled to the right against self-incrimination, which is one of the protections that might be afforded him in terms of Section 3 sub 4. So I'm just wondering, why do we have to say your duty to go to the commission rests on your obligation to account?
Justice Shafter, we would submit on that question that the court should express itself on both questions. Mr. Zuma is central to the work of the commission because he is the one witness that is expressly mentioned in the terms of reference, yes, and expressly mentioned by the remedial action of the public protector. But Mr. Zuma is also a former sitting president. The necessity for this court to express itself on the accountability duties flowing from the Constitution is that the court is deciding the law on this question.
Help me understand it. That accountability, how is it fulfilled? Is it fulfilled by his mere giving of evidence before the commission? Or is there anything else lying in that accountability? Bearing in mind that even though the commission was established as a result of remedial action, it is established in terms of section 84(2)(f). And we know from the jurisprudence of this court that once the commission has finished its job, made findings and recommendations and stuff like that, the president is not bound by any of those. He can ignore them. That's what this court has said in Sarfu and others. And we're not sure that definitely any action is going to be taken once the commission has made findings and recommendation. Yes. So I'm not quite sure how this accountability point factors in a scenario where the president who established the commission is still at large to ignore whatever is recommended by the commission.
Yes. So Justice Drafter, in relation to the first point, which is he required to account by showing up? We would say that there are three elements to accountability. The first is his attendance at the commission. And that is important for a number of reasons, one of which is that under Section 9(1), public perception matters. The idea that even a former president is not above the law. Mr. Zuma's conduct illustrates that he regards himself as being above the law. So the fact that this court has told him that he is not above the law is significant from a public perception point of view, because the rule of law should not only be done, it should also be seen to be done. The second...
I'm sorry, but that would be fulfilled by an order that says he must go to the commission, he must give evidence, and I think you said in your papers, he cannot invoke the right to remain silent. If we pronounce that he cannot invoke the right to remain silent, he will be obliged to answer questions except only those that can self-incriminate. So the point that you have made would have been fulfilled by that order.
Yes, I think what we are debating, Justice Drafter, if I'm not mistaken, is whether or not in the judgment you ought to express yourselves on the duty of accountability as a separate and a self-standing obligation. The question of remedy, I entirely agree with you that on the remedy, the order that compels them to appear and to answer questions fulfills both obligations. It fulfills the accountability obligation, and it also fulfills the mere compliance with the summons, if I could put it that way. But the reason why it's still necessary to express this court's view on accountability is because of the special nature of the commission and the special nature of the office that Mr. Zuma held. And the second element of accountability is that Mr. Zuma ought to explain, and that's not specific to Mr. Zuma, it is about the public. The public is entitled to his explanations of what happened during his term in office. And in that regard, accountability then serves to facilitate the investigation into the truth. And that is why it's necessary to express this court's view on accountability as a self-standing principle that is being vindicated. And the third, of course, relates to the nature of the evidence that he may give. We have already explained that it's not enough for Mr. Zuma to show up and, as his counsel has threatened, to say nothing. When he appears, he has no right to remain silent. And that also fulfills a self-standing constitutional obligation to account. Otherwise, accountability becomes an epithet, a mere word with no content.
Mr. Mugaitobi, on that same line of questions that my brother Jafta has put to you, if we look at Prayer 2 of the notice of motion.
Sorry, Justice Teron, I just need to get to that. Yes, thank you.
Which speaks about the constitutional obligation on the former president.
Yes.
And the duty to account.
Yes.
If this court is not with you on the question of the exercise of its exclusive jurisdiction,
yes,
would this court be able to grant the relief that is sought in Prayer 2?
Yes, it would be, because it would exercise its power as a court of first and last instance under the direct access provisions, particularly Section 167, 4A of the Constitution.
And the relief sought in paragraphs 2.2, 2.3, and 2.4. What is the point or the purpose of that relief? As my brother Jafta suggested to you or asked you earlier, if we are with you on the merits, and if you get past jurisdiction, should this court not simply order that Mr. Zuma appear at the commission?
No, Justice Terod, that would not be just and equitable. If we were not dealing with a witness with a history of belligerence, perhaps theoretically it might have been sufficient to simply order that the witness should appear. But if we just take them item by item, 2.2, it is necessary for the court to pronounce itself that he is obliged to comply with the summons if they have been validly issued and served under the Act. That is not a mere restatement of the law. It is a response to Mr. Zuma's conduct in terms of which he has acted in a way that shows that he does not regard himself as being bound to comply with the summons. In paragraph 2.3, that declarator is necessary. It's the declarator that when he excused himself and left the venue of the commission, that act was unlawful.
But
now
Mr.
that is, oh, sorry.
Yes. In respect of 2.3,
yes,
does the Commissions Act not make provision for the sanctions to follow upon somebody, not obeying or complying with their summons?
Yes, the only provision that is made in section 6.1 of the Commissions Act is a criminal procedure. What it doesn't make provision for is the procedure we have adopted, which is to obtain a civil declarator. And as the court knows, the mere fact that a statute allows a criminal procedure to be followed doesn't mean that civil remedies are not available. So the criminal procedure, as the papers show, has been followed. What we are asking for is a declarator, a civil declarator, that when he left, after his counsel had told Justice Zondo that he will be excusing himself, that was an unlawful and a breach of Section 3.1 of the Commissions Act. He will still be criminally prosecuted under Section 6.1 of the Commissions Act.
Would an order by this court in terms of 2.3 of the notice of motion not be preempting any criminal proceedings?
No, it will not be. It will simply be a civil declarator. We have to prove, the commission rather, not me. The commission still needs to prove in the criminal court that he acted knowingly and with the intention to breach the statute. The paragraph 2.3 does not even attempt to deal with questions of intention, which is the main issue that has to be proven in the criminal court. So it will not be preempting it. And it's fully justified. I mean, the case is made out in full on the papers that he actually never had any intention of answering those questions. And that's why we say that with respect, we are entitled to a declarator that his walkout, which is the correct characterization of his conduct, his walkout was unlawful and it was a breach of Section 3.1 of the Commissions Act. But it doesn't make it a criminal offense because under Section 6.1, we have to prove that he did so with the intention of violating the law. He may say, I acted with legal advice, which would excuse any criminal conduct on his part.
Are you suggesting, Mr. Muraitore, that unlawfulness in respect of a civil matter and unlawfulness in respect of a criminal matter are two different animals?
Yes, what I am suggesting, Justice Jafta, is that in the criminal court, there are specific elements we have to establish. Unlawfulness is one of them, but we cannot find him guilty of the crime unless we show that he acted with the intention to violate the act. That's the only point I'm making.
No, but the point that comes from the question by my sister is that by expressing an opinion, this court would have preempted any inquiry relating to unlawfulness in the criminal matter. So as I understand, the question is that because the court would have declared his conduct to be unlawful, it would not be necessary for the criminal court to determine again, and a court, let's say it's probably going to be a magistrate's court, a magistrate court to say, oh, despite the fact that the constitutional court said his conduct was unlawful, it was lawful. It won't happen.
Justice Jafta, we would submit with respect that the fact that this court has said on the papers available to it that from a civil point of view, the conduct is unlawful, is not binding on the criminal court. The criminal court must conduct a criminal inquiry and make a determination as to whether or not Mr. Zuma is guilty of the crime. That cannot be foreclosed by a finding made in a civil court. That's the law on the subject.
But what purpose will that declaration serve? You have told us that yes, he doesn't cooperate, he has no respect of the law. What purpose will that declaration serve?
Yes, thank you, Justice Jafta. That is, yes, thank you for that question. Two things. First is, the Commission's papers say, we do not believe, and I say this with the greatest of respect, we do not believe that despite Mr. Zuma having defied the chairperson of the Commission, we do not believe that Mr. Zuma will defy this court.
But why not? He has not even bothered to treat us with respect on your argument. He filed a letter to say, I'm not participating. Why would you think that he would respect an order of this court?
Yes, well, Justice Jafta, it's staggering. It's truly staggering to think that a former president would also breach an order of this court. It's truly staggering. It just defies logic and belief. But nevertheless, this court has held on numerous occasions the prospect of non-compliance with a future order cannot deter the court from imposing an order that is just and equitable.
No, that I understand, but the declaration has nothing to do with the future. The declaration has everything to do with the past. So I don't understand the link there.
Yes, but it is still a crucial declarator, because a declarator by definition is an expression of this court's opprobrium of that conduct. That conduct is central to this application, which is the walkout. It's necessary for this court to express its view on whether or not that conduct was justified or not.
Well, I'll leave it there. I'm not quite sure whether it will serve any future purpose, but I'll leave it there.
Justice Shafter, sorry, I know that you want to leave the point, but might I say one more thing?
Yes.
Justice Shafter, the law on declarators is that they are not only past looking, they are also future looking. In the future, another witness will conduct themselves in the same way as Mr. Zuma has done. It's necessary.
Do you want to go there? I thought you said this is an exceptional case. It's unlikely to happen in the future. Is it likely to have a president who would be accused of the same act?
No, I'm talking about another witness who believes that because of what I have observed and because the court was reluctant to express its opprobrium on the conduct of Mr. Zuma, because that moment of the walkout was the turning point in this case. And that's why I suggest with respect that a declaratory order expressing the opinion of this court on the walkout is essential to the court's judgment.
You see, I thought declarators are serving the purpose of clearing up the law, declaring what the law requires. Here, there's no need to declare the law. The law is clear. If a summons is issued by a commission to a witness, the witness is bound to obey the summons. If they don't do that, they're committing a criminal offense. So I am not quite sure, Mr. Mugaitobi, really, as to the purpose of the declarator in the circumstances of this case. But as I said, I'll leave the point there.
Justice Shafter, I will let you have the final word on this exchange. Can I go back then to Justice Teron's inquiry about, I don't know if it included 2.4.
It also deals, Mr. Mugaitobi, sorry, it also deals with prayer 3 as well, because you'd like us to order him to comply with a summons. And I thought that it follows that when a witness has been issued with a summons, they have to comply. So it doesn't just end in the prayers in 2, but also 2 to 3 as well, where you want us to issue an order that he is ordered to comply with a summons in the future.
Yes, but
I don't know what our order will, how our order will help you in those instances, because I thought that the nature of summons is such that when it is issued, a person then is required by law to comply with that summons.
Yes, but Justice Chico, I get the point. Paragraph 3 is different from paragraph 2.4. because paragraph 3 is the only specific order that relates to the future summons that has been issued to ensure that he complies with the summons of the 18th to the 22nd of January and 15th to the 19th of February 2021.
Yes, the point I'm making is that once that summons has been issued and properly served, then he is obliged by law to comply with that summons.
No, I agree entirely with that. He is obliged, but he has acted as if he is not obliged. And that is why this court's order is important to instruct him to be at the commission on the 18th of January. And as I submit, we would imagine it as staggering if an order by the Constitutional Court would also be treated with the same contempt. And the court cannot, in fact, be reluctant to tell him that on the 18th of January, he should be at the commission. And when he is at that commission, he should answer questions. The reason for this order is because Mr. Zuma's counsel told Judge Zondo on the 19th that he's walking out. He also told him, well, that he's excusing himself, which effectively amounted to a walkout. But he also told him that they were bringing an application for the review of the decision to refuse to recuse himself. We have dealt with that, anticipating an opposition, because it's crucial to say that notwithstanding your application for the review and the setting aside of the ruling, you are nevertheless obliged to be at the commission on the 18th of January. And paragraph 4 is, again, a different substantive paragraph, which is essentially that when he is before the commission, he is obliged to answer any questions subject to the privilege against self-incrimination. There is a debate between us and KSAC about
yes,
whether...
What do you say about that, Mr. Nkutobi, the divergence between yourself and KSAC on that?
Yes.
Not that we need included in our remedy, I don't.
Yes, I mean, what we say about this, the history to it, Justice Victor, is that the Commission had taken the view that under Section 3(4) of the Commissions Act, there is an express reference to the law of privilege in criminal proceedings as being applicable to the Commission. Now, KSAC says that that privilege should be narrowly construed to exclude the privilege against self-incrimination. Otherwise, one would defeat the objectives of the Commission, which is a truth-seeking enterprise. So that was the only basis on which the decision was taken. We would welcome the Constitutional Court finding that no witness is entitled to rely on the privilege against self-incrimination because it facilitates the work of the Commission. But the basis for it was that the text in Section 3(4) of the Commissions Act refers to the law of privilege applicable in the criminal proceedings would also apply. And the law of privilege in criminal proceedings is in the Criminal Procedure Act, and it expressly incorporates...
Except now, KSAC, sorry, Mr. Nkutobi, KSAC submits that he's not an accused person at the stage that evidence is given at the Commission. Not an accused person yet, and that's why he must answer everything.
No, I agree. That is the point they make. And as I say, the problem is that they still need to overcome the provisions of the Criminal Procedure Act, which say that a person is entitled to the privilege against self-incrimination. I take their point that he's not an accused person yet. Justice Victor, let me just re-emphasize here.
I'm sorry, Mr.
Nkutobi. Mr. Nkutobi, in the event that you assail the issue of direct access, I want to hear your views on what you say at paragraph 60 of your written submissions, wherein you explain that the privilege against self-incrimination must be claimed in respect of each question posed to a witness, and the judicial officer, before allowing the claim of privilege, must satisfy himself that there is a reasonable ground to apprehend the danger to the witness from his being compelled to answer. And you state that the danger must be real and appreciable and not of an imaginary and unsubstantial character. However, the cases we rely on here deal with the rights of arrested and accused persons and not witnesses before the Commission.
Yes, that is true. Can I go back to Section 3(4) of the Commissions Act? It provides any person who has been summoned to attend any sitting of the Commission as a witness, or who has given evidence before a commission shall be entitled to the same witness fees from public funds as if he had been summoned to attend or had given evidence at a criminal trial in a superior court held at the place of such sitting. And then it says, and in connection with the giving of any evidence or the production of any book or document before a commission, the law relating to privilege as applicable to a witness giving evidence or someone to produce a book or a document in such a court shall apply. Now that such a court is a criminal trial, a person summoned to give evidence. Now the question is, what is the law relating to privilege applicable to witnesses giving evidence in a superior court at a criminal trial? That law is in section 203 of the Criminal Procedure Act, and it provides witnesses excused from answering incriminating question. And it says, no witness in criminal proceedings shall, except as provided by this act or any other law, be compelled to answer any question which he would not, it says, on the 30th day of May 1961, have been compelled to answer by reason that the answer may expose him to a criminal charge. And we've explained there by reference to the date, to the case of Savoy versus NDPP and the judgment of Justice Madlanga at paragraph 37, which basically explains that witnesses in criminal proceedings are entitled to the privilege against self-incrimination. So that is how we got to the conclusion that Section 3(4) of the Commissions Act, read with Section 203 of the Criminal Procedure Act, clothe any witness with the entitlement to invoke the privilege against giving evidence that would be self-incriminatory.
My interest, Mr. Ngugaitobi, please indulge me, is where you then say in your prayer 4 that those witnesses may not exercise their right to remain silent. It bothered me a bit because I'm thinking that, yes, as you correctly say, those witnesses may not answer questions that have the effect of self-incrimination, but then the right to remain silent. And as I was thinking about this, I thought, well, the law is clear as far as Busak. Busak answers that if a witness does not answer a question, that witness then carries the risk that if he does not answer that those questions, then the trial fact, whether it's the commissioner or the court, may then accept the evidence against that person. And for as long as that person was given the opportunity to answer and did not answer. And I'm worried whether this court can then say that those witnesses who appear before this commission cannot exercise their right to remain silent.
Yes, the right to remain silent stands on a different category to the privilege against self-incrimination. The reason the privilege against self-incrimination is built into the statute, it's built into the Commissions Act by virtue of Section 3(4) of the Commissions Act, because it says the law relating to privilege will apply. So even if those witnesses are not accused persons, they are entitled as witnesses per se to rely on the privilege against self-incrimination. So, but that's built into the legislation by Section 3(4) of the Commissions Act.
Perhaps let me clarify my question. Yes. On what basis can we then say that they may not rely on their right to remain silent?
They have no such a right, because that right would be applicable to accused persons as per Section 35 of the Constitution. Unlike the privilege on self-incrimination, which is built into the structure of the Commissions Act.
But witnesses who appear in other tribunals, let's say the CCMA, the Competition Commission, etc., do have a right to exercise that right. Am I correct or am I wrong in thinking like that?
No, Justice Chikwe, in the CCMA, they don't have the right to remain silent. In fact, there is plenty of labor court authority that says that that right is applicable to criminal accused. You may elect, I suppose, to say, I will say nothing in my defense, but then you must accept that there will be a judgment. I mean, I can imagine if you were an accused employee and you are trying to get your job back and you were at the CCMA and you say that I want to say nothing.
Yes, that's why I referred you to BUSAC, to say that BUSAC is authority, to say that if you exercise that right to remain silent, there is a risk that the evidence that is against you that has not been disputed or challenged will then stand as evidence against you. And my anxiety is whether we can then force a witness not to exercise that right. And I'm thinking of a practical solution going forward for the commission to then warn that witness to say that there is law in this country that says that if you exercise that right to remain silent, then the evidence that is against you will stand unchallenged and we will accept it as if it was not disputed. Rather than this court to say that every witness who appears before that commission must answer the questions, even if they wish to exercise that right.
Justice Chipper, BUSAC is distinguishable because BUSAC was a criminal accused proper, and therefore they were entitled to the Section 35 protections. The commission is a different animal. It is a sui generis body. If witnesses are told that they are entitled to exercise the right and not the right to remain silent, in circumstances A, where that right is not provided for in law at all, they cannot point to the Commissions Act, they cannot point to the Criminal Procedure Act, they cannot point to the Constitution. The right simply doesn't exist as a matter of law. But if this court builds that right into the processes of the Commission, what would happen is predictable. The witnesses who should be answering questions, no one wants to answer questions before the Commission of Inquiry. It is an uncomfortable space. Every witness would jump on the entitlement to remain silent. What that would do is that the primary object of the commission, which is to investigate the truth, would be defeated. Take, for instance, Mr. Zuma. His conduct looms large throughout the commission. He is mentioned by title in the remedial action, mentioned by title in the terms of reference, mentioned by name by more than 30 witnesses. The court says to him, he has a right to remain silent. Question number one, is your name Mr. Jacob Zuma? I wish to exercise my right to remain silent. It would reduce the commission into a circus. And
I appreciate that. I appreciate that, Mr. Mugai Toby. It just struck me that Section 3.4 of the Commissions Act does not exclude that right from the rights that could be exercised by a witness. It simply excludes the law, the right of the law relating to privilege, but does not specifically say that. But such witnesses may not exercise the right to remain silent.
Yes, that is true. But I think the point, Justice Chipper, is if you then look at Section 3.1 and you look at Section 6.1, the obligation exists that questions that are put, because the reason you are summoned either to produce a document or to answer questions. But if you summon a person to answer questions and in the same breath, without any statutory provision, tell them that they are actually entitled to keep quiet, that simply frustrates the ability of the commission to perform its primary function as per Section 3.1 of the Commissions Act. And
Mr. Mukatobi, sorry to interrupt you. I think there's much to be said for CASAC's submission that Commissions Act and the Criminal Procedure Act and all other statutes for that matter must of course be read subject to the Constitution, to Section 35. So there's much to be said for the point that they make, that there can't be a right against self-incrimination which doesn't emerge from the Constitution itself. Be that as it may, I share the concern as expounded by colleagues now, and it seems to me you are dealing here with a recalcitrant, compellable witness, and you are seeking this wide-ranging relief, which frankly bothers me. I've said to you earlier that I'm concerned about the remedy, the relief that you seek. And is the answer not simply then for if you do get past direct access and all the other points, when you get to remedies, to simply order that he must comply with the summons, and that's the end of the matter? when it comes to questions of the right to remain silent, the right against self-incrimination, that is for the chairperson of the commission to deal with as it comes up before him on a case-by-case, on a question-by-question basis. Not so?
Yes. The first part of the question, I accept fully that the proper characterization of the witness is recalcitrant, perhaps defiant, but certainly not a willing participant. But on the second part, Justice Majid, the court must really ask itself what would be just and equitable in the circumstances of this case. Particularly bearing in mind that we already know from Mr. Zuma's counsel that he will be put on the witness stand and he will be advised to keep quiet. In those circumstances where those facts have already crystallized, we would submit that it is not just and equitable to merely say he must comply with the summons. It is also necessary to go a step further and to direct that in the compliance with the summons, the orders sought at 3, 4, and 5 should equally be granted. And that is what takes this case outside a normal case of a witness who is merely recalcitrant. Once one is dealing with a case where you have already been warned in advance what is likely to happen, and where you also have the provisions, as Kesa correctly points out, where you have the primary object of the commission being to investigate the truth. We will put a witness who will frustrate the ability of the commission to perform its functions unless the constitutional court tells him what to do when he gives evidence.
Mr. Toby, sorry, Regulation 12.2, sub A, it is required that the compellable witness must answer fully and satisfactorily any question lawfully put to him or her. Otherwise, they're guilty of an offense. That's Regulation 12.2.
Yes.
Now, it seems to me that CASAC is correct when it says that the witness cannot remain silent. Must answer the question satisfactorily.
Yes, we say so ourselves as well, Justice Victor. CASAC goes further to say the witness may not rely on the privilege against self-incrimination. I mean, I merely wish to emphasize that we would like a clarification from the court that says witnesses may not rely on the privilege against self-incrimination because that facilitates the work of the commission. The reason we've taken that attitude is because we've understood the text of Section 3.4 as incorporating the law of privilege, and the law of privilege is expounded in Section 203 of the Criminal Procedure Act. If CASAC is right that the correct construction of both of those provisions is through the prism of Section 35 of the Constitution, we have no objection to that argument at all.
Mr. Ngudai Toby, I have a similar concern to that of my colleagues, Justices Majid, Chitli, and Victor. Does the Commission not have its own machinery to deal with a witness who refuses to answer a question properly put to it? Why must this court make an order? And Justice Victor has referred you to Regulation 12.2.
Yes. Regulation, yes, that regulation says you must answer the questions truthfully, and then it says, well, there is then the remedy of a criminal trial. The criminal trial is punitive. That is its focus. It is to punish the witness. But what it does not do is to require the witness to answer. It's the threat of a future criminal trial. What we are concerned with here is civilly. We want a mandamus specifically compelling him to be present and to answer questions. That's the distinction we draw, Justice Teron.
But can this court give relief that is not encompassed in the Commissions Act?
Yes, it can give relief which is about the enforcement of the act, because if the act makes provision for a witness to appear and to answer questions, and the witness does not appear and to answer questions, a mandamus framed alongside the terms of the act is entirely appropriate.
Has the applicant in this case made out a sufficient case for that relief, Mr. Ngoetobe? Has the applicant said that if this relief is not granted, the Commission would not be able to fulfill its work or finish its work within the time frame? Or has the applicant merely said that the Constitution does not expressly afford commission witnesses the right to remain silent, therefore the applicant is entitled to that order?
Yes, I just want to check the pleadings, because my understanding of the case made out in relation to this part of the order is that the commission quotes verbatim statements made on behalf of Mr. Zuma on the first day, on the 16th of November, first day of the recusal application, where he expressly says, it does not help talking to the chairperson. It does not help you, Mr. Chairperson, to refuse our recusal application, because if you do, we will simply put Mr. Zuma on the witness stand and he will say nothing. So that case is expressly made out.
Can say they have no other relief available to them but the order sought in paragraph 4.
Yes, I don't think they say that in express terms. I just want to see what paragraph 4 is the requirement to answer questions.
Yes, and not to rely on the right to remain silent.
Yes, well, we do make the point that there is already an existing threat that he will be put and he will not say anything. And we say that a criminal sanction is not sufficient because it will consider the conduct of Mr. Zuma after the event. What it will not achieve is the accountability and the truth-seeking function, which is what a civil court is intended to enforce.
So it is the mandamus that you justify this prayer on the basis of a mandamus.
It is a mandamus, indeed. It is a civil mandamus. That
just before you move from that point, Mr. Mugaitobi, I just want to be clear on the relief in prayer 4. Do you realize that in section 8 of the Commissions Act, the prohibition against persons appearing before the commission, the prohibition against them refusing to answer questions is made subject to section 3(4) of the Commissions Act, and that section 12 as well makes that subject to section 3(4) of the Commissions Act. What is the effect of that? And if you look at your rules as well, make it subject to section 3(4). In fact, I said that in a vice versa order. Section 3(4) is the Act, and then the rules in Regulation 8 and 12, they make that subject to section 3(4). Meaning that what the kind of privilege that the witnesses have is only that against self-incrimination.
Yes.
As provided for in section 3(4).
Yes. We accept that. I mean, Regulation 8.1, the amended Regulation 8.1 says, no person appearing before the commission may refuse to answer any question on any grounds other than those contemplated in section 3(4) of the Commissions Act. And then Regulation 8.2 says, a self-incriminating answer or a statement given by a witness before the commission shall not be admissible as evidence against that person in any criminal proceedings brought against that person instituted in any court except in criminal proceedings where the person concerned is charged with an offense in terms of section 6 of the Commissions Act. So Regulation 8.2 makes it clear that the evidence is not admissible. In other words, it's not admissible as proof of the commission of the crime, but it is admissible in relation to what you have done at the commission itself, but not whether you've committed a crime or not. The criminal court must nevertheless prove its case. The privilege question is in Regulation 8.1, so no person appearing may refuse to answer any question on any grounds other than those contemplated in section 3(4). If you go back to section 3(4), section 3(4) is the incorporation we say it is the incorporation of the privilege against self-incrimination, which then takes us to section 203 of the Criminal Procedure Act, which says witnesses are excused from answering self-incriminating questions. So that's
I'm with you there. I'm simply saying that the Act and your regulations protect those witnesses only against self-incriminating witness statements. And I'm saying that what then happens to questions of a nature that the constitutional right to remain silent?
Yes, but they have no rights to remain silent, Justice Chico, at all. They just simply do not have the right, because that right under Section 35 is available to accused persons. These are not accused persons. Mr. Zuma is not an accused person in relation to the acts of alleged criminality that are the subject matter of the Commission's investigation. The NPA has not charged him. So he simply does not have that right at all. KSAC says the problem is that he also does not have the privilege against self-incrimination. And we've explained why textually we've worked on the basis that we have, which is on the text, Section 3.4, Regulation 8.1 and 2, and Section 203 of the Criminal Procedure Act seem to confer him with a privilege against self-incrimination. But it may be that a constitutionally consonant approach is the one that KSAC advocates for. If we have anything more to say on this, we will expand on it in our written submissions, which are due to be filed tomorrow. So on the right to remain silent point, they simply don't have the right at all. I mean, therefore, they cannot assert it. The privilege against self-incrimination is expressly built into the legislative matrix, and that's why we've been prepared to allow them to exercise the privilege against self-incrimination. If KSAC is right, then the Commission will happily take out the privilege against self-incrimination. That leaves justices the five.
Mr. Ngugai-Toby, I'm sorry,
yes.
just to round up on that one, because I am bothered by the approach that KSAC is advocating for. Is it not correct that Section 3 sub 4 of the Commissions Act constitutes legislation?
That's correct.
Is it not correct that in terms of Section 39 sub 2 of the Constitution, a duty is imposed upon a court in interpreting any legislation to promote the object and the spirit of the Bill of Rights?
Yes, that's true.
Now, does the Commission enjoy any rights in the Bill of Rights?
I mean, as the Commission?
Yes.
Or as witnesses appearing before the Commission?
No, as the Commission, as the institution. Remember, we call upon to individual rights. Yeah. Now, wouldn't Section 39 sub 2 direct us to interpret Section 3 sub 4 in a manner that advances the rights of witnesses?
I mean, yes. I mean, we've taken the approach based on purely on the text, without resorting to Section 39(2). But we've said the text binds us, and the text suggests.
Is there any other provision in the Constitution that requires legislation to be interpreted consistently with the Constitution?
No, but some statutes expressly say that, but Section 39 is the main provision.
Okay, I was surprised that you were trying to embrace KSAC's argument.
No, Justice Jaffe, is simply to explain what they say. I mean, we've relied purely on the text, but if they are right, we are happy to embrace their outcome.
Okay, all right, I'll leave it at that, because you're still going to file your answer to KSAC.
Yes, indeed. We will do so by close of business tomorrow. So just a few things that I didn't explain, which have just been brought to my attention by my junior, to refer to paragraph 147 at page 73. Yes, so that comes back to the issue we've debated, I think, in response to Justice Chikwe. And then the paragraphs 13 to 15, which is at page 147. Sorry, at paragraphs 13 to 15. Yes, that is at page 11 to 13. That is what explains why, notwithstanding the provisions of the Act and the terms of the summons, it is nevertheless necessary to obtain relief directly from this court. Now, what that leaves then is paragraph 5 and 6 of the relief. Now, in paragraph 5, it's just to correct the sequencing of that. I mean, it starts with unless excused by the chairperson. It doesn't read correct. I mean, it should start with the respondent is ordered to remain in attendance at the commission on those dates. And at the end, unless excused by the chairperson, that should be the correct way of reading that paragraph. But we've debated whether or not that paragraph ought to be granted at all. But sorry, Justice Setero.
Yes, while we're on the terms of the paragraph, to remain in attendance from 10 o'clock until when on each day?
It says unless excused by the chairperson. You mean the time? It would be 10. I mean, I think there's no end time. There's only a starting time. I don't know if the court actually ever watches the commission.
Is it to remain at the commission from 10 o'clock on the 18th of January until the 22nd of January, and then 10 o'clock on the 15th of February until the 19th of February?
Yes, the problem is that there's no end time. I mean, as I was making the point that if the court has ever watched that commission, sometimes it has finished at 6, sometimes at 8, sometimes at 9. So I think it's decided by the chairperson.
Until the end of proceedings for the day, or until excused for the, yeah, I just make the point.
Yes, I mean, what I had suggested there is to put a comma before the full stop and insert until such time as decided by the chairperson. I think the essence of the point is that there is usually a starting time, but there is usually no end time. And if the court told him to be there between 10 and 5, I think at 5 o'clock he would pack his bags and leave. So, that leaves paragraph 6. Paragraph 6 is also fully motivated. It's a standalone paragraph. We would like that order to be granted before the 10th of January, which is the date when he should be delivering the responses to the Regulation 10.6 directives issued on the 27th and the 8th of September. Those dates have also come and gone, and he has not complied with them. And this is an extension, a further extension, to give him until the 10th of January to file those. But it's a standalone paragraph.
Mr. Mugai-Toby, can this court order the respondent to comply with directives that have not yet been issued? The second part of paragraph 6 says, and any further directives under regulation 10.6. And I would have the same question for paragraph 7 as well. The respondent is ordered to comply with any directives that the commission may validly issue. Those directives may, in the opinion of the commission, be validly issued. What if they are not validly issued? Then this court is issuing a directive that the respondent comply with directives that might not have been validly issued.
Now, I think the point is well made, Justice Teron. Might I then deal with the issue of cost?
Sorry, Mr. Mugaitobi. Before you go to the issue of cost, the substance of the relief sought in paragraph 6.
Yes.
What does the Act say in connection with a witness or a party who chooses not to comply with the directive? What are the consequences?
Yes, the consequences are the same.
I'll tell you what my concern is, Mr. Mugaitobi.
Yes.
That this court might maybe being asked to grant relief that extends the possible relief that the commission could have got under in terms of the Commissions Act.
Yes. Yes. No, I think yes. All right. I mean, if one looks at the Commissions Act, I see the point that Justice Turon, you are raising. The Act allows the Commission to order witnesses to produce documents, attend witness and give evidence and attend the hearings. If you don't, under Section 6(1), any person summoned to attend and give evidence or to produce any book, document, or object before a commission, and who without sufficient cause fails to attend at the time and place specified in the summons, etc., it goes on, you then commit an offense. So there is a statutory offense created by Section 6(1). Then,
is there any provision, either in the Act or in the regulations, that compels compliance with the directive issued by the Commission?
Yes, in Section 3(1).
That is what the applicant is asking this court to do in terms of the relief under Press 6.
Yes. In Section 3(1), those directives were directives to produce affidavits in response to witnesses that had testified before the Commission. In Section 3(1) of the Commissions Act, what it provides for is that the chairperson of the Commission has the same powers as a high court to summon witnesses, to cause an oath or affirmation to be administered to them, to examine them, and to call for the production of books, documents, and objects. So there is a statutory power that is equivalent to that of a sitting judge of the High Court, which enables the chairperson of the Commission to ask for sworn statements or affirmed statements, to ask for oral testimonies, to ask for production of books and documents, or any other objects. So if we ask that you enforce the regulations that were directed at compelling Mr. Zuma to produce an affidavit, that is entirely within the framework of the legislation.
Mr. Ngugaitobi, isn't your answer perhaps in the Commission's rules? Because reference to documents and so on in 3(1) of the Commissions Act would be reference to, I would imagine, but of course you may edify me on that. I would imagine that's reference to books, documents, etc., that are in existence, and not something to be created, so to speak, by a witness upon being directed by the Commission. So the affidavit in response to evidence that's been given is something that is not in existence. So the witness is being directed to create it and to have it, come into existence. So I don't think that 3(1) is quite apt. But I would imagine, I doubt that the Commission would simply issue directives like that without a lawful basis for doing so. So I think in response to my sister Justice Turon, you should look elsewhere and not in 3(1). But as I say, I may be wrong and you may edify me on that.
No, Justice Matlanga, I mean, you are right. So there is the overarching statutory basis, which is you can bring a witness and compel them to give evidence. That's in the statute. Then there is the specific regulations, and specifically at Regulation 10.6 and Regulation 12.2D of the Commission regulations. Those would then be specific that one of the mechanisms that the chairperson may utilize to extract evidence from a witness is to compel them to produce an affidavit. And that's required by the regulations themselves. And what we are asking the court to do is to enforce the act, which is the overarching provisions in section 3.1, but specifically the regulatory regime in 10.6 and 12.2d specifically enable the chairperson to use this method to extract evidence from witnesses. These regulations, I'm just reminded, were amended. They were first issued on the 9th of February 2018, and then amended on the 16th of July 2018. So it's Regulation 10.6 and Regulation 12.2d. 6 specifically deals with evidence to be presented by to the Commission. And 10, which is under 10.6, also specifically refers to this method of collation of evidence. So that's correct, Justice Mazanga, in summary. And the narrow provision I should have referred to other regulations.
Mr. Ngugaitobi, sorry, before you go to court.
Yes.
You are asking the court to deliver a judgment and make an order before the 10th of January.
Yes.
Is that realistic?
Justice Chafter, it's not unrealistic if an order is issued with reasons to follow.
Well, you and I know the danger of issuing an order with reasons to follow.
Justice Chafter, I'm not a judge of the Constitutional Court, luckily for me.
Fortunately, I've acted as a judge in a number of courts that I know. So the question of judging, you know very well. So I am thinking here that on the Commission's own words, the Commission would also require Mr. Zuma to appear before 18 February. So
yes, that's the second set of dates, Justice Chafter.
I accept that, yes. So that seems to suggest to me that the period of January is for the convenience of the Commission, that it wants him to appear in January. If the court were to work out a judgment and an order that is delivered before February, the Commission can still rearrange his appearance before it, or it won't be possible.
No, Justice Chafter, I think I would be overreaching if I said it would be impossible. I think it's all practicable. I think the choice that was made, I mean, I didn't make the choice, but I think the choice that was made was because there are 30 witnesses that have implicated Mr. Zuma, 30. It's not going to be enough to set down 1 week for the evidence of Mr. Zuma, a period of 2 weeks. The other consideration was that there are many other witnesses that are yet to be called. But Justice Chafter, the direct answer is that I am sure that Justice Zondo can fill in the January dates with different witnesses.
Yes. And replace those witnesses who are going to come in February with Mr. Zuma's appearance to make up for the second week.
Yes, indeed. I think that will be practicable. I think that if yes, I don't think one can suggest that the January dates are cast in iron.
Okay.
Yes,
can I take you back then to the issue of direct access, which I indicated that it bothers me. And I want you to allay my anxiety here. My understanding of the law is that it is not enough to show exceptional circumstances. It must be circumstances of the nature that warrants the intervention of this court at the time it is asked to intervene? Or am I wrong?
This is Justice Jafta. Fortunately, only yesterday the court reiterated the test in the case of Moko. It seems that the exceptional circumstances standard, which come from the judgment of Justice Moseneke, is not linked to exceptional circumstances warranting an intervention at a particular time. They must simply exist. In paragraph 19 of Moko, this is what is said. I think it is a judgment by Justice Khampempe. It says, however, that does not mean that there cannot be exceptional circumstances where this court deems it appropriate to grant direct access to an applicant. And then it quotes, in Mazibuko, Moseneke TCJ noted that for the existence of exceptional circumstances, there must, in addition to other factors, be sufficient urgency or public importance and proof of prejudice to the ends of justice to justify such a procedure. So it seems that what we need to show is that there are exceptional circumstances. In other words, this is a case that is unlikely to be repeated because direct access is an exceptional procedure. And then we must show urgency, we must show public importance, we must show proof of prejudice to the ends of justice.
Yes, that's the leg that I think I'm interested in. Proof of prejudice to what?
To the ends of justice.
For example, if, for example, your client had gone to the High Court to obtain the same relief that it may obtain here, what prejudice would your client suffer?
I think the prejudice is delay, because inevitably a High Court procedure would have yielded an appeal.
But why do you say inevitably? What are the facts supporting that statement? Can you draw my attention to the affidavit and show me where that comes out?
Yes, it should be under the section dealing with direct access.
Okay.
So we deal with this at 24.
Paragraph 24.
Yes, that's where the first page on direct access.
Page 24, yes.
So at 28, from paragraph 36, we explain there why the court should assume jurisdiction as a court of first and final instance. And at 30, we deal with the urgency. At 37, we explain that it's brought under Rule 12. We say at 38 that the commission is required to complete its work by the 31st of March. And then we say that the genuine urgency of this application is demonstrated by the fact that ordinary procedures will not suffice. Very little time remains for the commission to finish its work and complete its report based on all the evidence presented before it. The deadline set by the High Court in its final extension is 31 March 2021. The commission's plan was to conclude the hearing of all oral evidence by the end of December 2020. That plan was upset by the COVID-19 lockdown, which meant that the commission lost 3 months allocated to hearings. The commission's work has also been frustrated by Mr. Zuma's conduct, which I explained below. Although the commission will not complete the hearing of all oral evidence by December, it will have to complete all oral evidence no later than the end of February 2021. Then it says, realistically, therefore, the only remaining time for the hearing of Mr. Zuma's evidence is between January and the end of February 2021. And then...
Do you think if Mr. Mugaitobi, your client were to go to the High Court seeking extension of the period? Actually, I think the chairperson has already indicated that he would until the end of June. Now, would the High Court not likely grant an extension if assuming, for example, that the dates were all fixed for different witnesses from now up to the 31st of March, wouldn't the High Court grant an extension for purposes of having Mr. Zuma to appear before the Commission?
I think Justice Drafter, perhaps just to complete that narrative, paragraph 43 then deals specifically with the High Court issue, which says the urgency of having final determination by this court is clear. Any relief would be ineffective if not immediately granted. The limited lifespan of the Commission means that there is an incentive for recalcitrant witnesses to delay accountability through court challenges and appeals. Any delay occasioned by this application having to work its way through from the High Court to the Supreme Court of Appeal and to this Honorable Court would defeat the purpose of this application, because in the meantime, the term of the Commission would lapse. Now, if we come back to the specific issue, let us assume, Justice Drafter, that an extension was applied for and granted for another period of 3 months. What that does is to take us to June 2021. In the case that you just decided in Moko, the period that was envisaged there was May 2021. That was the cutoff period when he would have to sit for his supplementary exam and when the court engaged its direct access jurisdiction. But assuming that we got the extension and the extension gave us to June 2021, a 3-month extension, the chance that we will get an extension longer than 3 months is almost impossible, because this is a commission that has already been in existence for 3 years now. When the commission was initially envisaged, the period was 6 months, and after extension, we are now at more than 3 years. The question then you have to ask in those circumstances is, does 6 months really make a difference? If you got an extension for 6 months, does it make a difference? Because there is no appeal process that will go from the High Court to the SCA and to the Constitutional Court that will be finalized in 6 months. It's just impossible.
No, but that's not true. That's not based on the facts. There's no standard period set that if you are to appeal to the SCA, it can only be after a year. It depends on the urgency of the matter and the arrangement to be made with the president of the SCA, as it does with the JP in the High Court, and I'm sure with the Chief Justice here. So I think that point is being overemphasized, that the period that would be taken if there were to be an appeal, it will be more than a year to the SCA and more than a year to come here. I'm not quite sure that I'm convinced by that. But you could also have an appeal directly from the High Court to here to cut short of the process. But there will be an appeal. What concerns me, Mr. Director, is this. And unfortunately, because Mr. Zuma has taken the stance that he has taken, it is this. When you are determining where the interests of justice lie in a matter like this, you also have to factor in the other party's right to appeal. You can't just ignore it because you want to reach finality. You have to factor it in and say, is it possible, if that party were to appeal, to be allowed to exercise its constitutional right within acceptable time periods for the matter to be finalized? That is where my concern comes from. The issue of saying, well, look, there's going to be a delay, and therefore you have to write off the right of appeal completely. To me, it doesn't seem to be advancing or upholding the Constitution insofar as the right to appeal is concerned.
Yes, no, I accept that as a general concern that the court must factor that in, but I think that it is not a concern on the facts of this case. Mr. Zuma, quite frankly, does not care. He has told us.
If he doesn't care, then he won't appeal.
No, Justice Drafter, what I'm saying is that he doesn't care about this point in this court. He doesn't care about his appeal entitlements.
It brings us back to, if we look at his conduct in this court, what is the likelihood? How do we get to an inference that if it were to be the High Court that grant the same relief, he is going to appeal?
Well, Justice Tafta, what we know for a fact is that he has dragged out the process. What we also know for a fact is that he has instituted his ill-fated review against the recusal decision. What we also know is that he told the...
We know that it is ill-fated.
Yes, the court does not have to express any view. In fact, we expressly say in our papers that the court does not have to express any view on the review. The only point where we are inviting the court to express a view on is that its mere existence does not justify his non-appearance. His entire conduct is conduct based on delay. And this point that Justice...
Toby, sorry, can I ask you this? He has specifically indicated that he doesn't want to participate.
Yes, precisely.
In these proceedings. Is that not a factor to be taken into account in relation to any potential appeal process that he would have been entitled to in terms of the Constitution?
Yes, in relation to any potential prejudice to be weighed against the necessity in the public interest for the matter to be held expeditiously, entirely.
I think that the point cuts both ways. If he is not interested to appeal, then an order by the High Court would be final because he is not interested to appeal. I don't see the point the way you're putting it, but I hear you.
Yes, but Justice Tafta, I mean, again, I don't want to have the final word in this, but Justice Tafta, what you have to take into account is that he is playing out the system because he has instituted a review in the High Court. He's definitely playing the system.
Well, it is difficult to say he's playing the system out insofar as the review in the High Court is concerned. One, I believe he has the right to take on review the decision of the chairperson. It is only the High Court that is going to determine whether that review is frivolous or not. So I'm not sure whether we can factor in that. But I understand your point to say, look at his past conduct. His past conduct is of delaying or trying to avoid going to appear before the commission. That I understand.
Yes. Thank you, Justice Chad.
It's often said that you should be wary of judges bearing gifts, but the applicant would only have known of the respondent's stance once, or they only came to know of the respondent's stance that he would not be opposing after they had filed their papers in this court.
Indeed. Thank you. I will accept that gift. It's Christmas time. Might I deal with costs, which is the final point? In the notice of motion, we've asked at page 4, paragraph 8, that he should pay costs on an attorney and own client scale, which is a punitive scale. But in the founding affidavit, we said that at page 73, paragraph 148, in the event that the application is opposed, a punitive cost order is sought on an attorney and own client. And then reasons are then tabulated from paragraph 149. And in the heads of argument, we then sought to clarify what may appear to be a contradiction between the notice of motion and the body of the founding affidavit. That we will persist for an ordinary party and party costs because the application has not been opposed. But it would be wrong for Mr. Zuma not to pay costs at all in the light of his past conduct and in the light of the conduct that he has displayed before this court.
Can you clarify which conduct before this court? I thought that you were referring to conduct he has displayed in the commission.
Yes,
what conduct specifically? Is it the fact that he responded by letter?
Justice Chiku, I think There are three things to be said about this letter. The first is that he responded by a letter. In circumstances where he is represented by senior counsel and is represented by attorneys who know that you respond to this court formally by documents such as notices, whether they are notices of oppose or notices to abide. But none of those notices have been filed. Secondly, the content of the letter is itself particularly objectionable because the letter says, I will not be participating, at all. If one has regard to the fact that historically, we have been trying to ensure that Mr. Zuma participates in the proceedings of the commission, his election not to participate before this court, as it were, at all, is itself illustrative of the general disdain with which he has been treating the legal system. And thirdly, Justice Chick, Mr. Zuma did not respond on the time frame that was set by the commission in its notice of motion. He responded after a direction had been issued, which was an extension of the period that was granted to him, an extension to the Monday, but he ignored the timetable that was issued by the commission. Now, I know this is high court procedure. The applicant decides the timetable. You comply with that timetable and you fail to comply at your own peril. Mr. Zuma was not even prepared to comply with the timetable decided by the commission. No notice whatsoever was given. And a mere letter which deprives the court the benefit of his explanation, particularly about the walkout. So his conduct before this commission and that letter is further evidence of the way in which he has been contemptuous to the legal system. And that is why...
Mr. Nwaitu, excuse me.
Sorry, Justice.
If President Zuma, former President Zuma, had filed a notice to abide, would your argument on costs be any different or would it be the same?
No, Justice Matopo, I would still ask for costs because we are using state funds to ensure his participation in circumstances where it is almost manifest that he is obliged to participate. We are also using state funds against someone who has displayed a very high level of recalcitrance. And in those circumstances, his conduct here is aggravation, but it is not the sole basis for the order sought for costs.
But would that letter that says we do not participate at all not be construed as a notice to abide?
No, it cannot be, because if you are
and if so, why not? Because the purpose and the purport of it is the same.
Yes. No, Justice Matopo, if you are represented by senior counsel and you are represented by an experienced attorney, you know the difference between a mere letter that says I am not participating at all and a notice to abide. And you also know the rules of the Constitutional Court, and you have also read the directives issued by the Chief Justice. It was a slight on the Chief Justice's directions. And one must actually confront the problem that we are dealing with. One cannot be generous in construing a contemptuous letter and give it some sort of respectability by clothing it with legal language. It was never intended to be a legally acceptable document. It was always intended, and it came across that way. It was always intended to tell everyone who intended listening or reading that actually you can do whatever you wish, I am not participating. So it would not be a proper characterization of that letter to say it was a notice to abide. A notice to abide, this court has seen many notices to abide. I have no doubt Mr. Zuma's lawyers have done many notices to abide, and they know how to do a notice to abide. This was a slight on the directions.
Thank you.
Was Mr. Zuma not cited in his private capacity?
He was.
Would BioWatch not apply?
No, we would argue on the exceptions to BioWatch, because BioWatch does not cover any form of recalcitrance. But we would say that this would fall under the BioWatch exceptions.
And which exception in BioWatch?
Well, you have to factor in the conduct of the litigant, and you have to factor in the consequences of that conduct.
You say factoring in the conduct, does it mean that we have to look at the entire conduct, his conduct before the commission and his conduct before this court?
Yes, we will submit, he should. Okay. And Justice Drafter, in fact, on this first question, which is in what capacity is here, it's true that he is cited privately, but it is also true, as the founding affidavit says, that Mr. Zuma continues to be a beneficiary of state funds. He's still being paid by the state. He still enjoys all of the privileges of being president. He is being called to the commission to explain his conduct as president of the country.
No,
and that is also...
I don't follow that point. Is a man not entitled to receive his pension? What has that to do with the issue of costs?
No, the Justice Drafter, he is entitled to receive the pension, but there is a correlative duty that comes with that entitlement, which is he should not frustrate the ability of the nation to know what transpired during his term in office.
Arising from him getting a pension?
Arising from the fact that he has continued enjoying the benefits of presidential office. Those have not been terminated by mere fact that he's no longer in office.
Do you have an authority for that proposition?
No, we haven't specifically cited an authority. This is a case made in the founding affidavit.
Okay, now let me leave it there.
Yes. Now, on the second point, which is the question of costs, specifically, what we say is that BioWatch does not intend to cover the kind of conduct, particularly on vexatiousness, particularly on the non-cooperation of Mr. Zuma with the commission, and particularly the way in which he has responded to this court. This is not the type of protections that BioWatch was intended for. BioWatch was always intended for genuine, good faith litigation, which turns out to have been wrong. We submit here that Mr. Zuma has not acted in good faith. His entire conduct has been characterized by malicious behavior. And hence, although he should not be paying costs on a punitive scale, he should be paying costs on a party and party scale. I think it was...
Does that conclude your submission?
It does, Justice Khampempe, with thanks to the court for accommodating us on the 29th of December.
Thank you very much.
The Registrar Clerk may conclude the proceedings.
I think that Justice Khampempe's computer appears to be frozen on my end, so I'm not sure if the...
Yes. Today's proceedings have concluded. The host will now terminate the meeting.
Well, Mr. Muraito, the judgment is reserved.
Thank you, Justice Chapter.
The court will now adjourn.
Thank you very much. We are indebted to the court.
We have Minister Begekele, we have Minister Ronald Lamula. We will be also be welcoming Minister Zwelim Kize, who's just wrapping up a meeting with unions. Of course, we also welcome to the message from government.